Good morning, everybody, and welcome to the webinar this morning on understanding the difference between misconduct, incapacity, and poor performance. Just to introduce myself, my name is Nikki Hardwick. I'm an HR consultant at HR Talk, and I head up the HR division as well. So just to welcome you to the session, just as a bit of housekeeping, the session will go on for approximately an hour. We will be able to share the recording of this session after the fact. It does normally take a few days, so it won't be ready tomorrow, but when it is ready, we will share with all the participants that attended today. All right, so the session today is predominantly to allow employers to understand the difference between misconduct, incapacity, and poor performance. So what is the difference? So in my experience, having chaired many disciplinary hearings, assisted many companies in dealing with misconduct, incapacity, and poor performance, I found that very often some of the challenges and a lot of the challenges that we have is a general lack of understanding in terms of what the difference is between the three. And as I go through the webinar today, it will become clear to you why it's really important that when you deal with the three, one, you as well as your supervisors understand what the difference is, because the consequences when we get to, hopefully not, but if you do get to a CCMA or bargaining council area, is that you will have a problem. Okay, so moving on to the very first slide. Common problems that are faced by employers when dealing with discipline, when dealing with misconduct, when dealing with incapacity, is that the employers as well as supervisors don't seem to understand what the purpose of discipline and what it means. And we take the understanding of discipline, and really everything that we're going to be talking about today is based on the principles that are found within the Code of Good Conduct, the Code of Good Practice, at least in terms of dismissals, and that is found in the Labour Relations Act. It is Code 8 of the Labour Relations Act, and it really unpacks for us as employers how we should be approaching things. So when we look at things like discipline, what is the purpose of discipline? Why do we discipline our employees? What are we supposed to be doing in that space? Very often people don't understand what needs to happen, and so they take the wrong approach. People don't understand the difference between progressive versus punitive discipline. And so, as an example, people have this, so I've heard before where people seem to understand that you must give 3 warnings for every transgression before you can go to a disciplinary hearing, which isn't necessarily the case, because progressive versus punitive discipline, is based on the type of transgression. So as an example, if somebody was coming to work late, you could possibly look at progressive discipline, which is the intention to try and rectify behavior. And so what you would do is you would slowly try and fix the behavior by issuing punishments that slowly got worse and worse and worse. So in other words, if somebody was coming to work late, you would initially start, for example, with a counseling to try and unpack why they're coming to work late. And then if it didn't come right, you would then move on from a counseling to possibly a verbal warning, which is not that serious. It only lasts for so much time. But then if the behavior still doesn't come right, you would then move on to something more serious, which could be a verbal warning, written warning, final written warning. And then if it still doesn't get any better, you would ultimately end up in a disciplinary hearing. The same approach, though, would not be if somebody had stolen from you. And the reason is because if you think about it, with punitive discipline, if somebody steals from you, you don't want to give them 2 or 3 or 4 chances to try and fix the behavior in terms of stealing from you again in order, for them to possibly come right. In that scenario, you can't allow them progressive discipline because the nature of the transgression is too serious. So depending on where your transgressions are and what has happened, sometimes you apply progressive discipline versus punitive discipline. The other challenge that we face is that there's poor record keeping. And I've had the argument from many employers that we now have to, put everything in writing. You cannot have a conversation with someone, and if it's not written, it's not said. So to a certain degree, that is correct, in that if it's not written, it's not said, but it doesn't mean that every conversation you have in passing, every time you speak to an employee, you have to revert it to writing. But if you've got to the point where you're starting to consider, inverted commas, more formal action like counseling, you've given the person a chance, whatever it may be, at that point, you need to start putting things in writing. So you can have a discussion, but you must follow up in terms of an email or something along those lines. Then a key aspect of this webinar today is understanding the difference between dismissals for poor performance or incapacity, misconduct, and then I've included operational requirements, although it's not a key focus of today, but there is a difference in terms of dismissing someone for operational requirements. Now, we talk about dismissals, and so not necessarily the process leading up to that, but when we look at the code of good practice on dismissals, is what they do in there is they define for us that if you get to the point of dismissing someone for one of those things, there are things that you needed to have done and fairness principles that should have been followed before the dismissal would have been fair. So at any time in our working lives as managers and employers, when we're dealing with employees and anything that needs to happen, we constantly have to think about the fact that at some point we may get to the point where we're possibly going to dismiss the person. And so we need to follow the correct process in order to make sure that that dismissal is fair. And then key aspect here is not following the correct procedure based on the type of issue. Okay, and we're going to go through that now in terms of trying to explain why the correct procedure is actually the key issue in terms of understanding the difference and making sure that your processes are correct to get to your end result. Okay, so when we have a look at understanding the processes that need to happen, a common issue that I'm faced with regularly is the approach that every single or many employers, implement within the workplace, which is to apply the concepts of discipline to every scenario. Okay, and what that really means is that somebody calls in sick, somebody is not performing, and so we work on a principle is that if we give them warnings, they will stop taking so much sick leave or they will start to perform better. But if we think about that logically, forgetting about the legislation, if you think about someone that is genuinely sick, okay, remembering we go back to there's different types of discipline, but discipline in its purest form is supposed to try and rectify behavior. That is why we discipline people. We don't discipline them so that they are punished. We discipline them so that the punishment would hopefully bring around their behavior. So going back to what I said before, somebody is coming to work late. It's a very simple example. So what I do is initially I have a conversation. Please, can we resolve this behavior? What's happening? You need to come to work on time. I'm hoping through my discussion that ultimately you'll fix your behavior, because the person coming to work late, in this instance, there is a rule and they are breaking that rule. If they continue to come to work late, they are making a choice to come to work late, and they can choose to change that behavior. Assuming they don't change the behavior, we then start to progressively discipline. And so I start to give, for lack of a better word, a harder and harder smack in the hopes that their behavior will fix. If it doesn't fix, we eventually end up in a disciplinary hearing and possibly they lose their job. But if we consider this particular slide, what we have here is we have a very, very sick person, and let's assume this is a person who is regularly off sick. Okay, giving the person a warning to say, if you don't stop being sick, you're going to lose your job. Now, remembering the concept, and when we go to the Labour Relations Act, and it'll start to make sense just now, that if you think about the concept of discipline, the concept of discipline is forcing, or at least trying to get people to change behavior by giving them a punishment. And so if we consider the fact that if people are sick, If you go to a hospital and somebody is genuinely sick and you say to them, if you don't get better, I am, for example, going to smack you, I'm going to issue a verbal warning, I'm going to give you a written warning, and if you don't sort this out, if you don't get better, I'm going to give you another warning. The very concept of what we're doing there doesn't make any sense. I know why people do it, and that is to try and stop people who are messing around. But if we think about the concept of issuing people warnings for taking sick leave, that doesn't make any sense, because you cannot change someone's sick leave or sickness by issuing them the warning. The same concept applies with a person who is not performing. I'm not talking about someone who is willfully not doing their work, possibly missing deadlines because they're messing around. I'm talking about a person who is unable to perform their duties due to no fault of their own. Issuing warnings to force them to change behavior that they're incapable of changing isn't going to help. Okay, so going on from there, just remembering this slide, we then move into the different aspects of the different aspects of the dismissals in terms of Schedule 8 of the Labour Relations Act. So the Labour Relations Act in terms of Schedule 8 defines different types of dismissals for us. And depending on where we're going, so at any point when we come to an employee who has any issue, so something has happened, our job is to look at that scenario and to decide which process we're going to be taking. So if we look at misconduct, and the way to define misconduct is to almost say it is an act or a mission to act by an employee. The employee has broken a rule. So it is something that the employee has done that they have control over to either change or not change. So even in the space of negligence, which could often be an unintentional act or a mission to act, which has then resulted in a loss, damage, harm, or whatever it is to the employer, the person's action or inaction has caused the fault. So because of what they did or didn't do, it has resulted in something, and they can change their behavior. Okay, so misconduct implies an ability on the part of the employee to change behavior. They have the ability to do or not to do something. Remembering it's an ability to do that. They have broken a rule, they have done something wrong. Then we go into incapacity, and I separate incapacity and poor performance. So they do sort of fit underneath the same element, but I'm going to talk about incapacity in terms of ill health and injury versus incapacity for poor performance. So the first one is incapacity for ill health or injury, and that is where an employee is temporarily unable to work, so they are incapacitated on the grounds of ill health or injury. Remembering that the temporarily unable to work is not necessarily 2 weeks, 30 days, when your sick leave is finished. It's at the point that the employee's absence from work is starting to create an issue for the employer. So the person is regularly, not at work. If you do the sick leave ratio, their sick leave ratio is getting to the point that it is above the norm. Okay, so if you look at any kind of incapacity, it is specifically related to ill health or injury. Then we have poor performance. And that is where the employee is unable to perform their duties despite being given training, guidance, and counseling and the work standards provided. So that is an inability, not a choice, an inability of the person to perform their duties. So when we look at poor performance versus something like negligence as an example, very often as employers, we almost need to determine at the beginning of something like that, whether we're looking at poor performance or are we looking at a misconduct issue. So when somebody is missing deadlines, when they are not meeting the standards that they need to do, generally employers will start in a poor performance space. And they might then, once they've started in the poor performance place of looking at training, guidance, counseling, etc., determine that the person has what they need. There is no reason why they should not be performing. And they then determine that it's actually not poor performance, i.e. an inability of the person to perform, and move it across to a misconduct. So sometimes it does overlap. The same as incapacity. Very often people, like I said before, will start incapacity with the belief that the person or persons are messing around, so they're taking too much sick leave, and so they go to misconduct and now say you're abusing your sick leave, and so I'm going to give you a warning. The best bet is always to start incapacity as incapacity. And when you determine that it's actually not incapacity, i.e. the person is not injured, they are not sick, they don't have proof of their illness, etc., etc., and we've determined that the person is actually not incapacitated, then we move it into the misconduct space. We also have, there's another section, and again, very often people will say probation doesn't work, it's a pointless exercise, but within the Labour Relations Act, the Schedule 8, they also talk about terminating employees within the probationary period. So in any other scenario, if we're looking at poor performance or, so the process which we'll go through just now, the process for dealing with poor performance in terms of the Labour Relations Act is very specific, even incapacity or misconduct. Within probation, they allow employers to follow a less onerous process within probation because it's a testing period. So I'll show you now, as we go through the slides, exactly what is required. Probationary period allows you less obligation in terms of having to follow everything that is listed in the other sections, even to the extent of when we look at incapacity. If somebody in probation starts to take too much sick leave, yes, there's the concept of no payment or whatever, but the person is still not coming to work. We don't have to follow the full incapacity process if the person is in probationary period. So a good probationary period managed correctly is actually a really good thing to put in place within your business, as well as ensuring that the probationary period is relevant, it's the right amount of time, etc., etc. There is a space in that time that you can terminate an employee's employment who's on probation in a much easier manner than if you don't have probation. I did mention before that there is obviously terminations for, or at least dismissals for operational requirements, which I'm not really going to go into because that is a whole nother session all on its own. Okay, so as we move forward, sorry, just moving the slide forward. Okay, so now we start to look at, so when we look at any dismissal in terms of the Labour Relations Act, we have to look at what, if it was ever challenged at the CCMA, what would we be looking at in terms of fairness? So each of the different categories will have different requirements in terms of fairness. They also have different requirements in terms of substantive fairness as well as procedural fairness. Now, when I get into poor performance, you'll see why it is different and why you cannot go the misconduct route when we're actually looking at poor performance. So if we look at dismissals for misconduct, a dismissal must, regardless of the reason, comply with two things. The one, it must have a fair or sound reason for taking disciplinary action. So there must be something, so within the Code of Good Practice, it says you must have disciplinary rules. So there must be a fair reason or a sound reason for taking that action. Secondly, you must follow a fair and correct procedure. Now, whether you have your own internal disciplinary procedure or you follow that is depicted within the Code of Good Practice, those are the two things that you as the employer need to follow in order for the dismissal to be fair. Okay, so if we then just have a look at the next slide. Okay, so here we go. If we look at the procedural fairness in terms of misconduct. So remembering, when we look at misconduct, we have to look at the definition of misconduct, and misconduct arises out of an employee's failure to abide by or adhere to the standards of conduct expected by the organization. So it implies some form of fault on the part of the employee. Remembering that when we look at things like negligence, very often the person has made a mistake, they have done or not done something which has resulted in loss, damage, or harm. So although the person never intended for any loss, damage, or harm, they still did or didn't do something that caused that. And so that would fall under misconduct. Okay. So although the person may argue it's not my fault, I never meant it, there is still fault on the employee's behalf. Okay, so if we look at procedural fairness, these are things that all come out of the Code of Good Practice. So these are things that when we're looking at CCMA and CCMA's determination as to whether or not the dismissal is fair, these are the kinds of things that they will be asking of you as an employer. So the first things first is they say that employers should have a disciplinary rule or regulation that provides a standard of conduct required by the employees. Okay, so there must be something that tells employees how they're supposed to behave. Okay. Now, again, remembering I said there's punitive versus progressive. So the Code of Good Practice says that wherever possible, we should try corrective discipline or progressive discipline rather than punitive where we can. So the intention of the Code of Good Practice is to try and correct the behavior. So you do something wrong and I slowly try and put you into the right place by issuing you disciplinary action that possibly gets more severe if you don't listen, in the hopes that at some point you may rectify your behavior. Okay, it does say that dismissal is not appropriate on the first offense unless that misconduct is so serious or repetitive, well, not repetitive, but is so serious that the employment relationship cannot continue. Okay, so the code says we should try and implement progressive discipline. We must conduct an investigation. The employee must be notified of the inquiry in reasonable time to prepare. Reasonable time, so the rule of thumb is generally 48 hours, but the person must be notified that it is happening. They must be told what the charges are. They must understand what the charges are or the allegations against them. They must be given the time to prepare. They must be allowed to respond. So generally that would happen in a disciplinary inquiry or a disciplinary hearing. So they would be allowed the opportunity to state their case, and where applicable, either a shop steward or trade union representative or a fellow employee. And then finally, they must be given the reason for dismissal. So if they end up being dismissed, they must be told why. Normally, that would all take place within a disciplinary hearing, and the chairperson or whoever it is that is presiding over it would do those things. Okay, so those are the requirements in terms of procedural fairness that an employer must follow in order for there to be no issue later down the line if it is challenged at CCMA. Then we get to substantive fairness. Okay, so the first question that is asked is, did the employee break a rule? Okay, so was there a rule in place and did the employee break it? If they did break the rule, we must ask ourselves the question, was the rule valid or reasonable? Okay, was the employee aware or could have been reasonably aware of the rule? Has it been consistently applied? And is dismissal an appropriate sanction? Okay, so I want to go back to the thing that employers do when somebody takes sick leave. Okay, so if somebody is taking sick leave, now my question is people will give somebody a warning because they were off sick. So my question is what is the rule? Okay, and how could the employee, by issuing discipline, have changed their behavior? Now, there are other ways of dealing with abuse of sick leave, but issuing people a warning because they were sick is not necessarily going to help you in this space. And when we get to incapacity, you'll see why. Okay. All right, so just going back a second. So there's the aspects of procedural fairness. So what are we required to do from a procedural fairness for misconduct, and substantive fairness? What are we supposed to do in terms of substantive fairness? Then we move on to dismissals for poor performance. Now, if we look at poor performance and the definition, so performance is about how the employee performs the tasks required of him or her as determined by the standards of performance for that position. Okay, so again, it can be complicated because it does border on, is it negligence? Is it somebody is willfully missing deadlines? They're just messing around. What is happening in this space? Is it no fault? Is it a will not or a cannot? So when we look at misconduct, we often will term that a will not. So somebody is choosing not to do something. okay, versus poor performance, which is a cannot. Despite what I do, I cannot fix this. I don't, as hard as I try, as much training as you give me, I actually don't have the ability to do what it is that you're asking me to do. Okay, so when we look at a dismissal for poor performance, what they require from us in terms of making that dismissal fair, remembering when we look at any sort of dismissal in terms of fairness, they look at procedural fairness as well as substantive fairness. Now, remembering the procedural fairness that was put in place for misconduct versus the procedural fairness that we're now going to go through in terms of poor performance. So, firstly, as the employer, you must conduct an objective assessment. Secondly, you must provide appropriate training, instruction, guidance, and counseling in the work standards required. Now, just a caveat on that is that if you have an employee who has been working with you for many, many, many years, you don't necessarily have to retrain them or re-give them the information in terms of the standards required if they have been performing adequately in the role for many years. Your obligation is to ask the question, is there anything else that they need in terms of training, instruction, guidance, and counseling? And if you're satisfied that the person has all of those things, then that's the only question that needs to be asked. So you don't have to retrain a person who has been there or reinstitute deadlines if the person has shown that in the past they were able to do so. Okay, then you must give employees a reasonable time to improve. Now, a reasonable time is going to depend, on the position. It'll depend on the organization. So you as the manager, you as the supervisor need to determine what that looks like. It is not a standard time. Each job will be different, and each scenario will be different depending on where the employee is falling short. We must then also investigate reasons for poor performance. So generally, if we look at somebody who is a new employee, okay, underneath probationary period, that is much easier to deal with because the person came in saying that they could do certain things, they're not able to do those things, and then we can terminate based on that. But if we look at someone who has been there for a number of years, so someone who's been performing, has adequately been performing in the role, never had an issue before and suddenly is not performing, that could be relating to family situations, financial stress, I don't know, an illness of some sort, but there is something that is causing it, or possibly we don't know why it's happening, but there is a reason. So we need to look at investigating the reasons for that poor performance. Okay, now this is quite an important one. If we look at poor performance, one of the things that we have to consider, it doesn't say we have to do it, but we must consider it as a job transfer. So if we determine we have a hearing and we determine that Nikki is not performing her job, we have given her training, instruction, guidance, and counseling. She's not willfully doing it. She is trying really hard. She's doing all of those things, and we've determined it is 100% poor performance. One of the things we then have to do is to go, is there anything else that Nikki can do in this company? That anything else that we may be considering could come with a drop in salary. It may have different hours, etc. So in essence, it could be a different job. And so we get into the place of demotions and that sort of thing. But remembering with demotions, that is an alternative to dismissal. So in this place, I would then say to Nikki, unfortunately, it has been determined that you are unable to perform these duties. You cannot do this job. I can, however, take that element away from you and give you this, but that's what it comes with. Nikki then says, no, thank you. I can't afford to live on that salary. I'm not happy. I don't want that. Then my only alternative, or I could give her an option to a different job or whatever it is, if I have them available. If Nikki says no, then my only alternative is to dismiss. Okay. Now, again, as with the misconduct, they must be allowed the opportunity for a shop steward, a trade union, if you have a representative union, or a fellow employee may assist. Okay, so in terms of that, now, just to stop at this point, and I've gone to a number of hearings where I go to a disciplinary hearing, which again is misconduct. And so in a disciplinary hearing, it is implied that the person is choosing to do this thing wrong. And the notice of the disciplinary hearing says poor performance and the person is being charged with poor performance in their duties and whatever. Okay, so if we then have a look at procedural fairness, so the obligations under procedural fairness for misconduct, if I go back my 2 slides here, okay, is we must have disciplinary rules, we must conduct an investigation, notify them of the inquiry, they must be allowed to, respond to that and be given a reason for dismissal. There is no obligation within here for us to offer an alternative position. So assuming we do a dismissal under a misconduct, so under a disciplinary hearing for misconduct, I now dismiss the person for poor performance under a disciplinary hearing for misconduct, and the person then goes to CCMA. Now, they go to CCMA and they now claim that it was an unfair dismissal, and they were dismissed for poor performance. If you go to the CCMA and the commissioner is then going to say to you, what was the person dismissed for? They were dismissed for poor performance. The questions that they're then going to start to ask you is, did you conduct an objective assessment? Did you do all of these things, provide appropriate training, etc., etc.? Did you offer a job transfer? Did you do these things? Your answer more often than not is going to be no, because you started the process by saying, this is a willful thing and I'm going to go down misconduct. So I gave the person a verbal warning, a written warning, a final written warning, and then I had a hearing and I dismissed the person. And so at CCMA, you're already on the back foot because you've titled the allegation poor performance. And then you've not done anything you should have done in order to make the dismissal fair. Okay. So when we look at any kind of misconduct or poor performance, you need to determine if you believe that the person is not doing their job properly, they are not performing. Make sure that you start with procedural fairness. So in terms of objective assessment, training, guidance, etc., determining, is the person not doing their job because they're unable to do their job, or is it a case of the person is 100% fine, it's not a case of poor performance, and then sliding it across into misconduct. But you must make sure that you don't mix the two up. If we're going to go to a disciplinary hearing for misconduct, don't use the words poor performance, because you are going to end up in a problem at CCMA because you're mixing up 2 very different principles in the Code of Good Practice. Okay, and a key aspect here is that you should be considering a job transfer, which is not required within misconduct. Okay, then if we look at substantive fairness, okay, so again, the substantive fairness for poor performance is different to the substantive fairness for misconduct. Substantive fairness for misconduct talks about a rule. Okay, over here we say, has the employee failed to meet a performance standard? Okay. Now, again, you don't necessarily have to put in job profiles and that sort of thing. It could be a generally accepted performance standard. It could be based on conversations. Now, remembering that I said in the beginning, for those of you that had joined in the beginning, one of the biggest problems in any of these things when we get to any kind of hearing, whether it be poor performance, incapacity, etc., is the failure on the employer's side to keep records. Now, again, I'm not saying that you have to record every conversation that you have, but as soon as it gets to the point where you're beginning to take this seriously and the employee at least is starting to fall short fairly regularly, the conversations that you need to be having need to be followed up in writing. And it could be as simple as an email confirming that, Heineke, we had a meeting today regarding XYZ, which you know that you need to be achieving. We spoke about why you're not doing it. You confirmed that you don't need training. You confirmed that you understand the deadline and X, Y, and Z. And you have also confirmed that next month this won't happen, as an example. And so you start to put the things in place in terms of confirming what was the performance standard, what was required, does the person adequately understand? So you don't have to have the job profile. I mean, they're good, and it takes away a lot of uncertainty, but if you don't have one, it does not mean that you can't go down this process. Okay. If they fail to meet the performance standard, and this is where we're coming in, where the questions are going to be asked, was the employee aware or reasonably aware of the required performance standard? So I've been in a number of hearings where the employee will then argue that they the deadline that they were supposedly supposed to meet, that it was never put in writing. And so they cannot be held to the deadline because it wasn't in writing. However, the evidence from the employer is that that deadline has been in place for a number of years, and the employee has met that deadline for a number of years. And so the employees will often state that it should be in writing, but that's not necessarily the case. So as long as you're able to back up your side of the story, and we can prove that the person was aware, then we can move forward. We also need to show that the employee has been given fair opportunity to meet the required standards. And then finally, if we do decide to dismiss, was it the appropriate sanction? So the question in that space that is going to be asked is, was there not another job available? Could you not change the person's job? Was there nothing else that you could do to limit the impact to the employee in this space, remembering that poor performance in this scenario implies no fault? Okay, so we're looking at an employee who has been fined for a number of years and suddenly starts to not perform. And again, it could be social. There's a number of issues that could be happening. It could be an incapacity thing. There could be, I don't know, a divorce. There could be a number of things that is causing the person's performance to go down. And our obligation as employers, which is different to dismissals for misconduct, is to try and help the employee, is to try and give them space to come right, is to give them support. And it's a very different place to saying you've broken the rules. Okay, so you can see in terms of the approach that has been taken for poor performance, that is a space where we try and help the employee. It's a much nicer approach. It's to try and assist, whereas dismissal for misconduct very often is very straightforward. You broke the rule, you didn't break the rule, whatever it is, but it's a much harsher approach. Okay, so there's the difference between performance as well as misconduct. Okay, then we move on to incapacity, remembering that, as I said before, in the Labour Relations Act, they talk about incapacity. So there's incapacity for ill health, and then there's incapacity for poor performance. In my presentation, when I refer to incapacity here, I'm specifically referring to incapacity for ill health or injury. Okay, so this is where an employee is has an inability to perform either all or part of their duties on an account of ill health or injury. Okay. And at this juncture, I'll do another webinar in which we talk about the management of sick leave. Is many employers begin this process assuming that every employee is obviously lying or trying to take advantage of their sick leave by having long weekends or, just abusing the system. Okay. And so when we assume that type of scenario, and we assume that the person is making a choice to take a day off, even though they're not sick, is to abuse the sick leave system, we're assuming that it is a choice. It is a choice that an employee can make. And so our automatic space is to go to misconduct, which we're saying it is the fault of the employee. And so if we give them warnings, hopefully they'll come right. Okay. The reality, however, is that as soon as we start to mix the sick leave with misconduct, is we now messing up our procedural fairness. We need to follow the process of incapacity to, one, determine that, one, the person is not incapacitated. They are, in fact, it's a choice and they're not doing what they should be doing, and then move to misconduct. But to start with misconduct, again, if you're going to end up in CCMA, someone is going to challenge you on the fairness, you're going to have a problem if you jump straight into misconduct. And I want to be clear here is that I'm not talking about, so when we talk about incapacity, there's various different things within incapacity on ill health. If a person doesn't phone in when they're sick, there is a rule that says if you're sick, you need to report your absence. That is a rule. You decided not to do it unless you obviously completely incapacitated that you couldn't use your phone, but that would have to be proven. So that is a break of a rule. If the person just doesn't come back to work for 3 weeks, okay, with no proof of anything, they don't notify you, that is a rule that has been broken, and so you can deal with it that way. If they come back to work and they have a medical certificate, well, there's two different processes. The one is you didn't notify me, you didn't tell me what needed to happen, so there's a disciplinary action aspect there. But there's another aspect here, which you were sick for 3 weeks. And so we have two processes that we need to deal with separately. Okay, so when we look at incapacity for ill health or injury, the first thing in terms of determining procedural fairness is we have a look at, is there a pattern of intermittent sick leave or lengthy absences from work? Now, a good way of looking at that is trying to determine a sick leave ratio, which is a little bit more, black and white in terms of determining if we have a problem. So very often people will use the Monday, Friday before and after public holidays as an indicator to determine if someone is abusing sick leave. Okay, the problem is that you may miss out on people who are abusing sick leave, but just don't happen to be doing it on a Monday or Friday. And so the better way of looking at it is to identify, so you can use the patterns, which is, it happens to be every second Monday or whatever it is, but then coupled with that is to work on a sick leave ratio. And we work on a sick leave ratio in which you can determine that, and you do it with every single employer, not employer, but every single employee. You take it over 6 months or whatever it is that works for you, and you determine your ratio, and every single person that goes over that ratio, so you could use 1.5 as an example, you then begin to have a conversation. So you're not picking on people that you think are messing around. You're now identifying patterns and lengthy absences for every single person within your organization. Okay. So the first thing is, and then you can justify as well your pattern of intermittent sick leave or lengthy absences. Another good one to use is the element within the basic conditions is the more than twice in 8 weeks. So in terms of the basic conditions, you have the ability to ask for a medical certificate if a person is off more than twice in 8 weeks or more than 2 consecutive days. So if a person is taking one day, and then another day, you can then call them in and say, you now need to bring a medical certificate every time you're off. But in addition to that, which is a pay issue, you can now start to identify that the person is actually taking a fair amount of sick leave. So it doesn't happen to be a Monday or Friday, but there's 3 occasions in a space of 2 months where this person is now taking sick leave. And if it continues, you're identifying that there is an issue. We're not assuming right at the bat, we're not assuming that the person is messing around, they're ducking and diving. We assume when we start the process that everybody has something wrong. And so we then move to the next step, which is we look at the extent of the employee's ill health or injury in terms of their job. So we start to chat to the employee, we possibly chat to their doctor, and we say, doctor, this is what the job is. Can Nikki do this job in terms of this? We then have a look at, is the employee capable of performing the work? So the doctor, the medical professional, whoever it is, will then say, actually, yes, now that you've explained what Nikki's job is, she's 100% fine. I then know that Nikki shouldn't be taking the leave, 100%. We then move on to a different process. And it might go down to, actually, this is a misconduct thing, but we've now started the process. We haven't gone down incapacity. Alternatively, we then determine that Nikki is unable to do a section of the job, and it's only for the next 2 months, or she can't do any of the job, whatever it is. We then, and this again is another key aspect, we then have to look at whether or not the employee's work circumstances or job can be considered for adaptation or modification. So as an example, if we take Nikki's job, her job requires that she deals with a lot of conflict. There's quite a lot of stress. There's a lot of multitasking, whatever it may be. And Nikki is now suffering from stress and anxiety, which is causing her to take a lot of time off of work. We then consult with my doctor. We then say, doctor, this is what Nikki's job is. She does X, Y, and Z. This is the stress, blah, 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 blah. Obviously, we have to do all of this with the employee's consent. But we then chat to the doctor, and the doctor says, actually, Nikki is currently being treated, but there's a large element of her job that I don't think she should be doing, or it should be reduced, for argument's sake, for the next 2 months. My employer then says, well, can we do that modification? Can we do that adaptation to allow Nikki to get better? As you can see in this process, again, much like poor performance, we as the employers are required to see how much we can help, to see what we can do to help Nikki through this process, that ultimately, where possible, she still has a job here. Okay. Whereas when we look at misconduct, when we get to the point of dismissal, we're not saying, hey, is there another job for Nikki where possibly she can still come to work late? Nikki has broken the rules. She's continued to do so, whether it was a serious misconduct or progressive discipline. We're sitting at the point where we're now dismissing. It's not a nice thing. You continue to break the rules. You're naughty. You don't listen, and I need you out my business. Performance or poor performance as well as incapacity are both no fault, and so the process and the approach that we need to do is a much nicer approach. Then we have a look at, is there an availability of suitable alternative work? So as an example, if the doctor then says, well, Nikki can't do a large portion of her job and she's never going to be able to do it again, my employer must then look and say, well, is there anything else that Nikki can do? Again, much the same as the poor performance. We would get to the point where we would have a hearing, an incapacity hearing with Nikki, in which we would speak to Nikki and say, well, Nikki, this is what your doctor has said. You know that you've been part of it. Your doctor has said that you cannot do this job. Okay, you're unable to do 80% of the job, and so we can't modify that. However, we have this job available. So this job doesn't require that. We've consulted with your doctor. Your doctor says you're able to do this job. But that job over there has an 80% reduction in salary, for argument's sake. Nikki then has the ability to say, yes, please, I would really like that job, in which case there's an agreement and off we go into the sunset. Everybody is happy. Alternatively, Nikki says, I can't do that, in which case we as the employer say we have no suitable alternatives. We've done everything. We offered Nikki the job. She doesn't want to take it. And then we then say there is nothing that we can do. And so we dismiss Nikki for incapacity. Remembering again, it's a dismissal. It's a no-fault dismissal, the same as poor performance. It is not Nikki's fault that she's too sick or incapacitated or whatever. It's a no-fault termination. Also, just remember that in terms of counselling and rehabilitation for cases of substance abuse and that sort of thing, the question will be asked is, what did we try and do to help Nikki through that process? Remembering that there's not necessarily an obligation for the employer to pay for rehabilitation, but the questions could be asked, for argument's sake, is Nikki needs 3 weeks off to go into rehab to help her through whatever. I, as the employer, say, well, sorry, I'm not accommodating that. Nikki's not going to be here, and so I'm just going to terminate her employment. If it goes to CCMA, they may end up saying, well, could you not have spared her for 3 weeks? Could you not have made an alternative arrangement? Could you not have done something to assist Nikki through this process? And again, I want to go back to, in probation, these things that I'm talking about are not required. You have a much easier approach within probation. You don't need to go through all of these things in probation. You don't need to look at available suitable alternatives. If somebody within probation cannot come to work, they've said that they're able, they said that they're capable, they said they could do what you said that they would do, they they don't fit whatever, you don't need to go through all these processes within the probationary period. As soon as probation is finished, these are the requirements that employers need to follow. Okay, so again, going back to, if I have a disciplinary hearing for misconduct, it's a disciplinary hearing in which I get a charge that says abuse of sick leave. Okay. We assume that we dismiss the person because we've given them warnings, they didn't comply, and now they say, well, actually, I'm genuinely sick, or even if I'm not genuinely sick, it doesn't really matter. But as the employer, I haven't followed the process, okay, because I'm going, the person is, they can choose not to do it, and I assume that they are lying and messing around or whatever. I go to a disciplinary hearing, fire the person for abuse of sick leave. It then goes to CCMA. They see the word sick leave, poor performance, whatever it is, and then they say, okay, did we follow the right process? And you are not going to have followed the right process because you followed misconduct. Okay. So again, as I say, we don't need to necessarily, it's not necessarily always going to be incapacity, but when it relates to ill health or injury, we start with incapacity. If it is a person's inability, inverted commas, to perform their job, they're missing deadlines, they're not performing at the right standard, start with performance. And then once you've done your investigations, you can then possibly move into misconduct. Okay. Alrighty, then we look at substantive fairness. Okay, so the substantive fairness for incapacity is looking at, is the person capable of performing the work? And if they're not capable of performing the work, we then need to look at the extent to which the person is unable to perform the work. Sorry, just to say again, when we're looking at if the person is capable to perform the work, it is not for the person to decide whether they're capable or the employee, if we're looking at incapacity for ill health or injury, because we cannot decide that a person is capable or not. So for those of you who have been around for a number of years, and I'm talking many, many, many years, way back when there was that whole light duty thing. So people would be booked off, and then the doctor would write on the medical certificate that the person was allowed to perform light duty, which generally meant that in a factory type of environment, the person would sweep. Okay, so that was what light duty was. Now, if we consider if a person has been booked off for a back injury, sweeping is not light duty. And so as the employer, we cannot decide what is light duty and what is not. We cannot decide based on the person's, illness, whether or not they're capable or not capable to perform the duty. So we have to engage with somebody who is able to do so. So again, that will be a medical practitioner. That'll be generally the person, if it's a genuine case of incapacity or ill health or injury, the person will have a consulting doctor. Remembering as well that, sorry, just to say that when we look at absence from work, so absence from work for ill health or injury, sometimes that may relate to a social issue, in which case there is no doctor. It's got nothing to do with any kind of illness. There's a social issue in which there is another, we would go down counseling and assistance from that side of things. And it actually ends up being not an incapacity issue, but possibly a poor performance issue. Okay. So when we look at the person not being capable, we look at the extent to which the person is unable to perform or able to perform the work, the extent to which the employee's work circumstances might be adapted to accommodate any disability, and or where not possible, the extent to which the employee's duties might be adapted. So there's a number of things. So depending on what the person's incapacity or injury could be, if it's a mental type of disability or illness, we may have to adapt the type of job or the stress levels or something along those lines. If it's a physical incapacity or injury, we may have to adapt if the person needs to stand or sit or not climb upstairs or whatever it may be. And then we finally need to look at, is there any availability of any suitable alternatives? Okay, so those are the things that we're going to be tested for when we go to CCMA, if it is challenged at CCMA. Or bargaining council, they are going to ask us those questions. And so it is key that you follow the process in the right space. It is key that you go down the right process because those things are going to be asked. I also would like to say, sorry, as I go through the overview here, is please be very careful of when you have somebody that you no longer want to have in your employ. They annoy you, you don't like their face, they're doing whatever it is that they're not doing, but you don't want to follow the right process. And so you make the decision to retrench them. Okay. I'm not going into that process today, but I do want to share with you that retrenching someone out of the blue just because you're actually hiding the fact that you don't want to follow another process, the requirements under operational dismissals is far greater and is highly regulated in terms of making sure that you as the employer are following the right process. You cannot just decide to retrench one person. There's a number of things that you need to do. And if those things are challenged at CCMA, you could end up having to take the person back. So just looking at what are the remedies at CCMA. So the first one is reinstatement. Okay, so if you have followed the wrong process and you've done the wrong thing and you cannot justify why the person was dismissed, there is the possibility of reinstatement. And reinstatement often comes with back pay from the time of dismissal to when they're reinstatement. Then you've got the option of reemployment. Okay, well, not you. The CCMA can award those, which is reemployment, which is you need to take the person back in any position. Reinstatement is generally back into their own position. Reemployment is you must just take the person back. Reemployment can come with back pay. It doesn't always, but it can. And then finally, there's compensation. The worst one, obviously, is that if your intentions were good, so somebody was incapacitated, they were not performing, but you followed the wrong process, you don't want to be in a position where at CCMA they're forcing you to bring the person back because the situation is what it is. It was happening, but you followed the wrong process. Okay. And then, okay, so just to recap, if we then have a look at the three different elements. So again, we got probation on the side, and in probation, any of these things can be dealt with. The requirement, though, is much less. Okay, so misconduct is we are disciplining employees to teach them our rules or our code of behavior using punishment to correct that behavior or that disobedience. Okay, so again, we are implying that it is a fault of the employee or the employee has the ability to change their behavior. So they have an ability to correct what they're doing. They have the ability to do something different. They can come to work on time. They can change things. So this whole concept of misconduct is saying, I'm going to smack you in the hopes that you choose not to do this again. Okay, poor performance is we're ensuring that employees are understanding of the requirements. They know what they're supposed to be doing. We're allowing them time to improve. We give them training, counseling, etc. in the work standards, and then we must consider a job transfer. Okay, sorry, let's just say we should consider a job transfer. So if it gets to the point of CCMA, that is the question that is going, did you consider all alternatives to dismissal? Okay. This one, however, is there's no fault of the employee. So no amount of punishment is going to change anything because the person physically cannot change what is wrong. And then we get to the incapacity, which is obviously the ill health or injury. So the employee is unable to perform their duties. We must look at, can modifications be made to the position? Can the employee be offered an alternative position? Again, we are looking at no fault termination. Okay, so the processes that we need to follow are very different, and it's really, really important that we follow the right things. So I think I've shared this already, but where it goes horribly wrong is we say Jenny has failed to perform her duties, which has resulted in a loss to the company. So we would then look at gross negligence or dereliction, which is dismissal. So we would follow our hearing and off we go. We then go to CCMA and Jenny says, actually, this wasn't a misconduct thing. It was actually poor performance. And they are then going to ask us if we followed the right things. Okay, so those are the things that you need to be starting to do. As I've said before, we need to look at progressive versus punitive, and just very quickly is understanding the difference between progressive and punitive. Is progressive discipline is understanding the process of using increasingly severe steps or measures when an employee fails to correct the problem. Okay. So just jumping back, so we must look at minor transgressions. So those are things where you can progressively discipline and treat it much the same as if you have children. Let's hope we don't smack them or ground them for a month for something that we could have a conversation. So much the same as we would, talk to people to slowly, hopefully get their behavior right, is the same process that we would apply with discipline. Major transgressions, we don't necessarily need to give 3 warnings or even 2 warnings. Sometimes we can go straight into a final written warning or dismissal. Okay. Alrighty. Okay, so the basics of misconduct in terms of looking at the different types of warnings is we then look at verbal warnings, written warnings, final written warning, and a demotion as an alternative to dismissal. The disciplinary hearings, these must be dealt with based on your disciplinary procedure and in line with the Labour Relations Act. So in terms of misconduct, those are the three types of punishments that we would look at. We could start with counselling, which is trying to fix the problem, and then we move into verbal warnings, etc. Okay, moving on to the next slide because I am kind of going over my time. Okay, but in terms of the incapacity, as I've spoken, in terms of the labour relations requirements, in terms of incapacity, we need to look at if the person is temporarily unable to perform work. And this is actually taken directly out of the Labour Relations Act. How long they're supposed to be off, is the person capable of performing the work, has the job been adapted, or can we do that? And then the cause of incapacity is sometimes relevant, especially when we're looking at alcoholism and drug abuse and that kind of thing. So we would try, again, in terms of the Labour Relations Act and in terms of our process, we would try and fix those. Okay. All right. So in terms of the Employment Equity Act, just to say in terms of incapacity, so it is not unfair to discriminate against anybody on to distinguish, exclude, or prefer anyone on the basis of the inherent requirements of the job. And so how we can do that in testing of an employee for medical reasons, we can do if we're looking at medical facts, employment conditions, and the inherent requirements of the job. So just stepping back into incapacity over here, as I've mentioned before, we cannot decide whether or not the person is able to perform their duties in terms of incapacity. I cannot decide what light duty is. I cannot decide if the person, if I give that person that job to do based on whatever is wrong with them. I think it's fine, but I'm not a doctor. So what we have the ability to do is to send the person to a medical practitioner, or with the person's permission is to speak to that person's medical practitioner to explain what has happened, their absence from work, and ask for a report from the doctor to determine whether or not they are able to do the job that I'm requiring. And so in doing that, we end up following that exact process over there to determine that the person is able or not able to do the job. Remembering that when we do this thing with the employee and the doctor, if the doctor comes back and says, actually, Nikki is more than capable, there's nothing really wrong with her and she should be able to do her job, we then have a meeting with Nikki to say, well, actually, Nikki, you now need to come back to work. Okay, so that brings us to the end of our session today. Like I said before, understanding the different processes that we have within the Labour Relations Act. It's not a complicated section to read. If you look at the Code of Good Practice on dismissals, it assists you in making sure that when you start the process of dealing with an employee, is that you deal with the correct element of that. As I've mentioned before, we will share the slides for today, or at least the recording. It does take a couple of days to convert it into something that can be shared, and so we will share it when we are ready. Unfortunately, it will not be tomorrow, so please be patient. When it is available, we will share it with you. But if anybody has any queries or anything that you would like to ask, please feel free to email my office. You can email us at hra@hrtalk.co.za. Or you can give us a call and we're happy to assist you. Remembering the requirements, so you need disciplinary rules and regulations, you need to have a process, and I would probably say what is really important is that your supervisors and managers and the people that are tasked with doing this understand the differences of these two, because that's actually where the problem begins. Mpule, you've got a question?
How are you?
I'm good, thanks, and you?
I'm well, thank you for the session. It was very informative. I just have a question. What happened in incident whereby we have an employee who's currently on a fixed term contract. And during the fixed term contract, we did check in with the employee more than 3 times. The first session, the employee indicated that she's struggling, and the line manager as well have identified a couple of the key performance areas that she's currently struggling with. The employee was provided with training. Still after the post-training, the employee is still struggling. Can the fixed term be terminated?
Yes.
And can we also, after that, send an ad and appoint someone? Or how can we approach that scenario?
Okay, so within a fixed term contract, you can you would follow the same process. So you would follow exactly the same process, unless, of course, whatever was happening came to a conclusion at the same time as the end of the contract. But if the contract is still, a way to go, you would do exactly what you've done, which is, I assume it's poor performance. So you would follow the poor performance route, you would do what you needed to do. And then ultimately what would happen is you would have a performance hearing in which you would go through those elements of poor performance. So have you been given, so you would have a meeting with the employee and you would say, this is what we have done. These are the areas that you're not performing. We've had several meetings. You've had this and this and this and this. We are at the point where we believe there is nothing further that we can do. We have considered alternatives, and our space is saying we believe we've got nothing else to do, and give the employee the opportunity to say whatever it is that they want to say. They may offer other alternatives. They may say that they need more training, at which point you would respond and say the training we've given is sufficient in terms of everybody else. And then ultimately you would make a decision and terminate the employment following the process. Remembering, because it's no fault, there would be notice, not necessarily that the person would work that notice. So I hope that answers your question.
Yes, thank you very much.
No problem. Okay, we have another question. Okay, Floyd.
Sorry, I was just trying to unmute myself.
No problem.
No, thanks, Nikki. I just wanted to ask, with regards to poor performance, obviously misconduct has the basics of verbal warning, written warning, final written warning, so on. When approaching poor performance and incapacity, how would you approach that with regards to like verbal discussion, and then is there a warning that comes in? Is that the same process you'd follow as misconduct and misconduct for the two, incapacity and poor performance?
So, okay, so we'll just separate the two. In terms of poor performance, what I would probably do is I would probably, much the same as we would have a counseling session where we have follow-ups and that sort of thing, I would follow the approach of that type of thing, which is we would have a meeting with the employee. We would say, these are the standards that you're not meeting. What are your reasons for not meeting that? Do you have any, do you need any support, et cetera, et cetera, et cetera. And we would then record that. So it could be on a form, it could be in an email, whatever it is. And then you have a follow-up date. So we're going to be monitoring you over the next month, for argument's sake. You have said you're going to do X, Y, and Z. We will do X, Y, and Z, and we're expecting an improvement in performance. And so the second meeting, you would then say, here we go, this is what we said in the first meeting. So it's not really a warning, because again, a warning implies discipline. And so the second meeting, which would be follow up, you would say, okay, hang on, you said you were going to do X, Y, and Z, you didn't do it. We gave you blah, 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 blah. We've given you a month, what has happened? And you almost have conversations. And then you get to the point where eventually you say, we've exhausted everything. So it doesn't need to be months and years or whatever, but you have your documentation backing up does that make sense? So you've got your
same principle. You're following the same process in principle, but it's just obviously following a different approach. You're not being, like you say, that punitive kind of approach. You're going more of a supporting approach.
100%.
To
the point that eventually you say, okay, look, we've done everything. Okay. And then if you go with incapacity, so that's a little different, because within incapacity, so my process generally with incapacity is that where okay, so I normally do an assessment of sick leave for everybody. And then those that go over the sick leave ratio and or there's an identification. So I'm not talking about somebody's been booked off for a month, but you know, where there's a problem. So my first point of call is that I would then you know, have a meeting with the employee to say, as you're aware, our process here is if you go over, I don't know, let's say 1.5, we have a meeting to say we've noticed in the last 6 months there seems to be something. So here's your sick leave. You know, the process that we would have to follow in terms of labor relations is X, Y, and Z. Is everything okay? Do you need any support? Do you want to tell me anything? And remembering, if we work on the 80-20 rule, 80% of your problem is going to come from 20% of your employees, and most employees are not genuinely sick. It just might be that people are taking a little bit of time. Most employees will kind of go, oh, okay, hang on, you know, I didn't realize you were watching, and the sick leave will taper off. And so your very first meeting is going, here we go, I'm just confirming, we had this meeting, your sick leave ratio was X, Y, and Z. We have agreed that I'm going to be monitoring you over the next 2 months. If it doesn't come right, we are going to then institute the formal process, which is I need to do an assessment of your job. I need to look at your sick leave. I need to speak to your doctor, obviously with your permission, but we're going to go the incapacity route. People who are not genuinely sick do not want you speaking to their doctor, and so the sick leave will stop. Okay.
Okay.
Those that are sick, you know, will probably genuinely be relieved and are happy to go down the process. The caveat here is the people who are taking sick leave due to social problems, because they're not gonna, they don't have a doctor, but you have to almost try and extract that. Okay, so it is kind of, so that's a very different process.
Okay. I suppose that you got to treat it with a bit of caution and understanding. Okay.
Yes, yes.
All right, perfect. That explains it. Thank you.
Good stuff. Okay, are there any other questions from anybody? Okay, well, if there's no questions from anybody, finally, again, saying thank you to everyone for attending the session today. The email address I've posted in the chat. Thanks so much for attending, and we will see you hopefully next week.